Suppose again that the former boxer mentioned in modules 12 and 13 is on trial for assault. Let's add a few wrinkles. The alleged assault occurred at night under poor lighting conditions, and it looks like the defense is going to claim misidentification, that the boxer didn't do it, that it was someone else who beat up the victim. Further, suppose that the assault occurred in a rather odd fashion. It did not come about through a punch or a kick, but simply through the assailant using his finger to flick the victim's ear with such force that it caused severe injury. Assume that the prosecution has evidence suggesting that the boxer previously injured someone else last year in this same fashion by rearing back his finger and flicking the person's ear with such violence that it hurt the person's ear. May the prosecution introduce this evidence at the former boxer's trial for assault now? It depends. The defense will argue character propensity, that the prosecution wants to introduce this evidence to show that the defendant is a finger-flicking madman and that he acted in line with this peculiar violent tendency during this occasion. The prosecution, however, will argue that the other act is being introduced to show the identity of the assailant, that this is the defendant's modus operandi, in effect, and that therefore he committed this assault, especially since the Three Stooges have met their makers by this point. The judge then will have to weigh whether this in fact is being introduced for the valid purpose of showing identity, or whether it is character propensity evidence in disguise. The outcome of that analysis may hinge on whether the judge thinks that using a finger to flick someone's ear in this manner is so idiosyncratic, so unusual, as to rise to the level of a signature crime that essentially the former boxer and the former boxer alone must have committed. Finally, recall that even if a judge rules that the evidence survives Rule 404B, that it is being offered for the valid other purpose of proving motive, the evidence could still be excluded under Rule 403 if the judge finds that its probative value is substantially outweighed by countervailing considerations, such as the risk of unfair prejudice. This module represents an example of a potentially valid other purpose for introducing Rule 404B other act evidence.